All persons having business before the Honorable Chief Judge and Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save this United States in this honorable court. This honorable court is now in session. Please come to order.
All right, good morning. Welcome to the District of Columbia Court of Appeals for argument in the Oliver McBride versus United States case. This is our only matter this morning. Are parties ready to proceed? And I guess before we proceed, if I could ask how appellant and amicus intend to proceed during this argument.
Thomas Healy, may it please the court, Your Honor. Thomas Healy on behalf of Mr. McBride. Mr. McBride is going to take 5 minutes to discuss mootness and cede the remaining 10 minutes for the substantive issue to the Public Defender Service.
All right, thank you. And I see Mr. Maneri arguing on behalf of the Public Defender Service, and I also see Ms. Weidman, who is sitting in on the oral arguments in the supervisory capacity or co-counsel capacity, I see. All right, good morning, everyone. Are you ready to proceed? I would also just note we have sitting with us today, in addition to Judge Roy McLeese, we have Judge Neil Kravitz, who is sitting by designation on this panel today, and we thank him for participating.
Thank you, Your Honor. Thomas, may it please the court, Thomas Healy on behalf of Mr. McBride. This Article 1 court has the discretion to decide this matter, even though the results will not affect Mr. McBride. This court should exercise that discretion because of how Rule 35 interacts with pleas taken under Rule 11C1C. It's an important issue, and there's important factors that I think you should consider. There are a large class of people who can raise a claim under Rule 35 after a Rule 11C1C plea. Of those people who raise the claim but have short sentences, including misdemeanor sentences, are people whose sentences are capable of repetition and of avoiding review. This case has been fully briefed on the merits, so even though Mr. McBride can't benefit, similarly situated people can.
Mr. Hill, may I interject just briefly? You encourage and cite in your brief United States versus Semler case from the Ninth Circuit, which talks about certain exceptional circumstances where pleas under 11C1C, C1C can be reviewed using the Rule 35 vehicle. But Semler had, other courts have sort of added or expanded or revised or tweaked in some ways the test and analysis in Semler. How would you, what's the test you would carve out here as to why we should consider this issue, which might under other circumstances be viewed as moot?
Well, I think the suggestion Judge Salerno made at Mr. McBride's sentencing, when Mr. McBride had raised the medical issues that had come up prior to sentencing, Judge Salerno said, if you're, let's see what BOP can do to solve your issues. And if they can't, then your attorney can come back and file something with me. At that point, we came back because we didn't believe BOP could actually deal with the exceptional physical problems Mr. McBride was suffering from. So it has to be something unique, something that's happened that's changed the character of the defendant's life or the circumstances of the defendant's life, not just a run-of-the-mill activity. There's a similar case I was appointed to on Friday, where in March 2nd of this year, a young man pled guilty under Rule 11C1C. Last Wednesday, he was stabbed at the jail. On Thursday, he was to go to sentencing. He appeared at sentencing, so I don't know the extent of the stabbing injury. But because of the stabbing, he asked the judge to withdraw his guilty plea and let him go to trial. Judge delayed sentencing, and then I was appointed the next day to review the withdrawal of his plea. And logically following this through, given the tests for withdrawal of pleas, it's possible his withdrawal of the plea motion will be denied. And we'll be looking at what the collateral or direct effects of the stabbing at the jail were. If the BOP can't handle the medical issues that came from that stabbing or the collateral consequences of it, then I could be before you in 5 or 6 months with another Rule 35 plea if the judge in Superior Court follows the same reasoning as Judge Salerno, that he doesn't have the ability to act on a change in circumstances after sentencing in a Rule 11 C1C plea.
Can I ask you, counsel, getting back to your mootness issue, you mentioned two different doctrines, and they're somewhat different, and I want to make sure I understand whether you're relying on both of them independently or how they fit together. So you made reference to the idea that at least for certain kinds of defendants, those serving short sentences, a claim like this might evade review. And that's an exception. I mean, Article 3 courts can rely on that doctrine. And if they determine that a claim is capable of repetition yet will evade review, the court can decide it, an Article 3 court can decide it. So that's one doctrine. The other doctrine that you're mentioning is that this court is an Article 1 court, and so we're not strictly constrained by Article 3 limitations. So even if this case doesn't fit within the capable of repetition yet evading review, this court has some discretionary authority to consider it anyway. Are you making both those arguments independently? Are you kind of combining them into an Article 1 argument? Or I'm not quite sure how your points fit together.
Sorry, sir. I was really trying to focus it as an Article 1 argument, following through from Edwards through Tyler, and then this court's later decisions in, for example, Tichy v. Carver, 736 A. 2nd 998 at 102. Moore v. Gaither at 767 A. 2nd 278 are examples, again, of how the Tyler doctrine or Tyler precedent has been applied for similarly situated defendants.
Can I ask you on the issue of how likely this issue is to recur, or how central it is to get an answer, and important it is to get an answer sooner rather than later? One way of looking at that would tend to point in the other direction is, this issue has been available to be raised in the trial court and to make its way to this court for quite a while. And this is the first case where we're aware that it's been teed up. And you look around the country and you can find some cases about it. Now, federally, because of the amendments to federal law, they don't really come up so much anymore. But in the states, you can find a smattering of cases about it. But it doesn't so much have the feel of this is a central issue. It's critical that this court address this question now, even if the case is moot. So what's your response to that? Why do you think it is critical? And let me factor in one other feature. If the position that you are advocating is, it's not like defendants in this situation are going to very easily get relief. If you acknowledge that only in extraordinary circumstances would they be able to get relief, it may not be that there are tons of folks out there who would benefit from an answer sooner rather than later to that question. So what are your thoughts on that related set of questions?
I think that the uncertainty in the trial court, both between defense attorneys, judges, and the prosecution as to how these two rules interact may be chilling the actual filing of Rule 35B motions. Once a defendant is sentenced and the case is closed, particularly under the CJA appointments, the attorney's case, it's concluded. There has to be a reason for the attorney to look for a post-conviction activity to bring back before the court. And right now, there's no real incentive because it's unclear what the interaction of a Rule 35B or 35 motion would be for a closed case attorney. And so I think the lack of filings are more focused on just simply the procedural posture of the cases and how attorneys are looking at them. And then for the judges, the question would be, I guess I'm moving off, let's not go to the judges at this point. So I think the uncertainty as to how Rule 35 applies when you have an 11C1C plea has sort of chilled the activity that could come before you. And this case is going to, it's a large class of misdemeanants and short sentence felony defendants who this would apply to that could evade the review.
Mr. Healy, I haven't sat in the misdemeanor calendar for many years, but do you have any sense of how often Rule C1C pleas are entered in misdemeanor cases in Superior Court?
Rarely, but what it usually happens is that a felony breaks down to a Rule C1C misdemeanor plea. I had a case 2 years ago where someone was charged with kidnapping. And as they got close to trial, in the day before trial, we were able to negotiate a plea to 2 counts of simple assault, which were run concurrently to each other. So the defendant would spend a year in jail. So it's more likely to come from small felonies breaking down, smaller gun and drug felonies, frankly, than it is major felonies. And in misdemeanor pleas, there would have to be some level of uniqueness to it. I had a client with the Office of the Attorney General who had a third DUI that was during police week in town. And so after she hit someone in a in a crosswalk, an off-duty police officer from out of town stopped her. The costs of bringing him in for trial and the evidence was so overwhelming that it made better sense in that case for OAG and the defendant to agree to a specific sentence for time served than to incur what would be a significant cost of bringing people from, I think it was an officer was from Oregon, into town. So there's got to be, again, a unique circumstance for a C1C plea to come into play in a direct misdemeanor case, but it does occur. And so, in closing, my belief is that there is a reasonably large class of people who this applies to, primarily misdemeanants, or people who plead to misdemeanors or have short sentences, and that this interaction, when it occurs, when there is a unique and specifically unique problem that needs to be addressed post-sentencing, giving everyone certainty exactly about what the interaction of Rule 35 with Rule 11 would benefit the efficiency of the court. Thank you.
All right, thank you, Mr. Healy. I know we took you beyond your 5 minutes, and so we will still give Mr. Manieri 10 minutes for argument. And if you'd like a minute for rebuttal, we'll allow that as well, Mr. Healy. All right, thank you.
May it please the court, Paul Manieri on behalf of the Public Defender Service. I would also like to reserve 1 minute for rebuttal. If this court does reach the merits of the issue presented in these appeals, it should hold that Rule 35 permits a trial court to reduce a sentence imposed pursuant to an accepted Rule 11C1C agreement, where the sentence is plainly unjust or unfair in light of the information that the trial court receives after sentencing the defendant. That interpretation of Rules 11 and 35 is correct for 3 reasons. First, it is consistent with the most analogous precedent from other jurisdictions, including the Ninth Circuit's interpretation of similar federal rules in United States versus Semler, which is the only federal court of appeals case to directly address the issue presented here.
Mr. Manieri, I did want to explore your thoughts on Semler further, but I had understood from the amicus brief that, and maybe I misunderstood, that amicus essentially agreed with the government that this was a moot appeal. And so if we were to agree with that, are you suggesting that we go further in and say more, even though we might view the matter as moot?
No, Your Honor. I think if this court decides that after the reasonable exercise of discretion that this case should be dismissed as moot, PDS sees no reason why the court should go further and clarify the issue. Also, from our perspective, I don't think that the issue is one that urgently needs clarification. However, we recognize that given that this is an Article 1 court, that there is a flexible mootness doctrine. And so my addressing the substance of the issue is purely in case the court does reach the substance of the issue, then obviously PDS has an institutional interest in that.
Good. And then, well, in that regard, then let me ask you the same question I asked Mr. Healy is how should, if we were to follow some of the reasoning in United States versus Semler and other courts as they may have tweaked or adopted it, what would that test look like for us? And what should it, in your view, as amicus, that test look like?
I think this court should really adopt Semler if it reaches the issue again. The Semler rule, pretty much in its entirety. I mean, the federal rules that were interpreted in Semler are essentially the same as the DC rules that are now in effect. The government does point to the fact that in Semler, Rule 11 did not yet have the binds the court language that was added in 1999 to the federal rule. But Semler was quite clear in its view that Rule 11 nevertheless did bind the trial court at sentencing. It pointed to Rule at the time 11E3, which read, if the court accepts the plea agreement, the court shall inform the defendant that it will embody in the judgment and sentence the disposition provided for in the plea agreement. And Semler says that Rule 11E3 prohibits a district court from sentencing a defendant to a sentence less severe than that provided for in the plea agreement accepted by the court. So
leaving aside the conceptual side of it, can I just ask you practically how you think the Semler test should operate? And let me give you a hypothetical. Imagine that a defendant negotiates, and the United States negotiate an 11C1C plea to a particular term of incarceration. And then imagine that a day later, the defendant files a Rule 35B motion and says the following. I haven't disclosed this to the United States previously, and obviously you don't know the Superior Court, but I've known for some time that I am suffering from a terminal illness, and I only have a certain amount of time to live. So I would like you to reduce my sentence from the sentence that was imposed yesterday by half. That's information the district court received after sentencing the defendant. And it's your view that is it your view that would be a legitimate basis upon which the trial court could reduce the sentence while leaving the plea agreement otherwise in place?
The short answer, Your Honor, is yes. I would note, I don't want to fight the hypo, but I would note that would seem unwise for the defendant to wait until after the sentence has been accepted by the court to bring it to the court's attention. I think it would be much more likely that the defendant would want to bring that information to the court and undo the plea agreement before it's ever accepted. However, if for whatever reason the defendant wants to wait and take his or her chances with the trial court, I think it would give the court authority to reduce the sentence under the rule that we proposed. Of course, the trial court would have the discretion to say, I see no reason why you couldn't have brought this information to my attention earlier, and hold that against the defendant. We're not asking that this court establish a rule where the defendant must have their sentence reduced in the posture that we're describing, just that the trial court has the authority to consider that motion.
I suppose, Mr. Maneri, that another way of articulating that is that the trial judge could say, well, you sat on this information, you didn't share it with me, I therefore conclude that your sentence was not plainly unjust.
I think that would be a reasonable exercise of discretion, yes.
Yeah, the reason I asked the hypothetical, though, is that although you focus on Semler as a test, but some of the other courts around the country that are open to these kinds of claims have different tests, and some of them do instead of responding in the way that you have, which is, well, there's authority in the trial court, but the trial court would have discretionary ability to take that into account. some courts make that part of the test. And so you really can't, the trial court is just barred from granting relief unless it's sort of newly discovered information that wasn't previously available. But your view is that the better version is similar. And let me just step back for a second. So I get that, but let me step back for a second and ask you, where do you think conceptually these limitations come from? Why isn't the answer to all of the possible limitations about, all of this kind of the discretion of the trial court? And there's really no test other than the trial court should do what is, not an abuse of discretion. If your conceptual view is Rule 11C1C, the language that your opponent relies upon, is all about initial sentencing, that's all that 11C1C constrains, then why is there a special test under Rule 35B conceptually in cases that are 11C1C pleas? Because your conceptual view is, yeah, those limits are all about initial sentencing. They aren't operative post original sentencing. So can you explain conceptually where those limitations are coming from?
Sure. I think in Semler, the concept that gives rise to the test that they establish is the court's duty to reconcile the rules. And they recognize that Rule 11 does not directly mandate that the trial court be bound after sentencing, but that to say that the trial court would have complete discretion after sentencing would in some way undermine the purpose of Rule 11. And so there's this reconciliation of the purposes of Rules 11 and Rule 35.
So it's kind of an extra textual requirement that's imposed as part of a kind of an implicit reconciliation process. Is that fair?
I think that's the conceptual move that Semler makes.
And some courts take the view, like the Colorado court that you cite, takes a kind of a different reconciliation approach and says, well, maybe there is authority. This is a paraphrase, but one way of looking at it conceptually at least is, well, perhaps there is authority to reduce a sentence under Rule 35B or some analog, even in an 11C1C setting. But that really can't be done unless the whole plea agreement is going to be unraveled. Because that, any reconciliation that allows a defendant to keep the benefit of the original plea agreement, but then, and hold the United States to all of it, or the, whatever the state prosecutor might be, but then to kind of chip away and get additional leniency benefits is just fundamentally inconsistent with 11C1C or similar provisions. What's wrong with that different, more restrictive, extra textual reconciliation of the provisions?
Well, I think, Your Honor, the remedy available to the government is not an issue that's presented here. They haven't asked to be able to withdraw from the plea agreement if the trial.
No, but you're asking us to announce a test. And so one test might be the trial court may grant relief under Rule 35B in connection with an 11C1C plea only if, as part of that relief, there's some agreement between the parties that the original plea agreement will be withdrawn, which ultimately means you can't grant it because, that's not quite right. It might be that the United States or the prosecutor would say, we'd rather let the judge decide the 35B motion and not unravel things, back to ground zero. So sometimes the prosecutor might waive this right if there were one. But it's a question of kind of what the test is, not so much what remedies anybody's asked in a particular case.
Sure. So I think in that case, Your Honor, you kind of hinted at it that the government would have sort of undue sway there to really preclude the defendant from actually filing a true Rule 35 motion. Because the government would just say, well, if you're going to do that, then we want to undo the plea agreement. And that's not the motion that the defendant would be making. There is a separate motion for withdrawal of the plea agreement, but the defendant would be making a Rule 35 motion. As for, what's wrong with that test from a fairness to the government perspective, I would point the court to the Virginia Court of Appeals rationale in Esparza, which says that laws in effect at the time that the plea agreement is made form part of the plea agreement. And so if the government wants to have the benefit of the bargain that the defendant is unable to move for Rule 35 relief, that should be in the plea agreement. And to the extent that it's not.
The logic of that argument, why doesn't that argument take you to the idea that the trial court should have complete freedom to resolve a Rule 35B motion in an 11C1C plea without any kind of ad hoc or interpolated balancing provisions. And if the prosecutor wanted to prevent that general authority that the trial court has, it's on the prosecutor to secure a plea agreement that forecloses that avenue of relief. So again, that line of thinking seems to be somewhat inconsistent with the limitations imposed in Semler that you are endorsing. You're advocating that we should adopt.
I think that is a tension between Semler and Esparza, and we rely on both of those, so I acknowledge that. I do think, though, that in Semler, the court considered the bargaining interests of the government and thought through all of this and reached the test that it reached. I do think Semler was maybe ignoring the point that the Esparza court talks about, but I don't think that means that the Semler test is wrong or that this court shouldn't adopt it. I think the court could sort of agree with the Esparza approach and say Semler was wrong and that the government's bargaining interests are not as great as the Semler court assumed, because the government has the ability to bargain away or to ask the defendant to bargain away his right to Rule 35 relief. And this court could ultimately reach that conclusion and say that Rule 35 does grant broad discretion to the trial court that's limited only by the reasonable exercise of discretion and the government's ability to put into the plea agreement that the defendant may not move for Rule 35 relief. I would sort of offer an alternative way of getting to this Semler rule, a different conceptual way than what Semler did, which is to say that the plain text of Rule 35 gives the trial court broad discretion, but this court's abuse of discretion jurisprudence still limits the way that the trial court can exercise that discretion. And there still needs to be a reason in the record that the trial court relies on in order to grant a Rule 35 motion. And so if that reason is something that was in the record before the plea agreement was accepted, then that would really be an abuse of discretion for the court to grant the Rule 35 motion, because if the reason was there before the court accepted the plea agreement, what they should have done was reject the plea agreement.
Well, was that reason there in this case to some extent? Wasn't that the defendant's or the appellant's medical condition known to the trial court prior to sentencing, the severity of his injuries? I know one of the things you argue in your amicus brief is if we do get to the merits, that we should remand for the trial court to determine if it's necessary to adjust the sentence under Rule 35B. But would that exercise be more form over substance here in terms of what was known at the time of sentencing by the trial judge about the appellant's medical condition?
Well, certainly here, I think the need for remand has passed, because I think everyone agrees, including Mr. McBride, that Mr. McBride would not get any relief from this court adopting the rule that we propose now that he's out. Assuming hypothetically that Mr. McBride were not out and that this, he could still get relief, I think it would be a tough question. Obviously, the trial court did have some of the information before it about the injuries that Mr. McBride had received. But I think that the Rule 35 motion was responding to the court's invitation that if Mr. McBride's lawyer, if Mr. Healy wanted to, he could take steps to address the BOP's inadequacy in terms of medical care. And so
wasn't the issue in the rule, wasn't the complaint that was articulated in the Rule 35 motion not that he was injured and had medical conditions, but that the Bureau of Prisons was not providing adequate care, something which was not in the record at the time of sentencing because it hadn't happened yet?
That's correct. The basis was the BOP's medical care, which is obviously closely related to the injuries, but is different from the injuries themselves.
What if any impact, and I know this was sort of raised in some of the briefing, but not squarely perhaps teed up by appellant, the supervised release period of time. Um, does that have any impact from your perspective on the mootness issue? I know that Mr. McBride asked for the reduction in his period of incarceration. He didn't specifically address the supervised release period of time that follows, but do we need to look at whether that has any bearing on the whole question of mootness? The fact that even though he may be released from custody, he still has this period of supervised release that places some obligations on him before he fully completes his sentence.
I don't think that affects the mootness question, both because Mr. McBride's motion did not implicate supervised release. And also it's my understanding that even if it did, that the trial court would have separately not had discretion to reduce the supervised release term because that was statutorily mandated. But I think primarily the issue there is that the Rule 35 motion just did not address supervised release at all.
Mr. Maneri, I wanted to just go back to your statement a few minutes ago that PDS does not see this as an issue that urgently needs a ruling. Putting to one side whether that really is the standard for when this court exercises its discretion, I guess I was surprised to hear you say that, because my impression is that a large number of the a large percentage of the PDS clients who plead guilty under Rule 11 C1C. And I would think that this is an issue that your clients and the lawyers who represent them would want to know the answer to.
I think, Your Honor, what I was referring to there is that we see no reason why, if that issue should arise in one of our cases, why it can't come up in that case, and that to date, it hasn't come up enough frequently that we think that we just can't wait until this issue does arise in one of our cases. And I would also note, I think, getting back to our discussion of trial court discretion, we understand that this is a hard standard to meet, the standard that we're proposing. And so even if we have a lot of clients who enter into C1C agreements, we understand that the trial court is going to deny Rule 35 motions under the standard that we propose in a lot of cases. It still might be beneficial to know that that is the standard, but it's not as though we think that adopting this standard is going to give rise to Rule 35 relief for a lot of people. It might open up different possibilities, but again, we're really talking about a narrow class of cases where a C1C agreement is accepted by the court, and then something unforeseen happens that affects the fairness of the sentence. And so that particular circumstance is one that we just don't see that often, despite the fact that, yes, C1C agreements are themselves common.
To the extent you know, is the possibility of Rule 35 relief for a defendant who's pled guilty under 11 C1C, is that something that lawyers at PDS have been aware of before we asked you to come in as amicus? And if not, how do you think that will affect what happens in the future until this court decides the issue?
I think it is something that our lawyers are aware of. Again, we just recognize that unless there are pretty extraordinary circumstances, a trial court that believes that a C1C sentence is appropriate is just not going to grant a reduction in that sentence. And so, notwithstanding our knowledge that Rule 35 continues to operate in C1C agreements, there's just not that many scenarios where we think that we would have a real chance of persuading the trial court that the Rule 35 should be granted.
All right, thank you. Mr. Lorenz?
Thank you, Your Honor. Good morning, and may it please the court. Dan Lenners for the United States. There's no disagreement that the outcome of this case cannot benefit Mr. McBride, and thus that the case is moot. Mr. McBride asked the court to use the somewhat rarely invoked capable of repetition yet evading review standard, but there's also no real dispute that that standard as it binds Article 3 courts isn't met, because the second prong of that standard, which requires that the same complaining party have a reasonable expectation that the same action would occur to him again, is not met here. And so Mr. McBride's really asking the court to exercise its discretion to decide this case solely because the first prong of the capable of repetition yet evading review standard is met. But even that's not really met here. This is not an issue that's going to consistently and recurringly evade review. It may in some rare instances, but in the vast majority of C1C pleas, there's going to be enough time for this issue to be resolved by the trial court, given that a Rule 35 motion has to be brought within 120 days, and that the trial court is required by rule to decide that issue quickly. And then for this court to be able to weigh in if the trial court denies it based on a lack of authority under Rule 35.
Mr. Lenners, do you have any data as to the number or percentage of C1C pleas that are in cases that have short enough sentences or to evade review? I mean, this case, a 30-month sentence, and actually his sentence got started, his prison time got started later than is usually the case where someone gets 30 months, because most people who get 30 months are detained. So have spent a significant period of that, a significant part of that 30 months in prison before the sentence is even imposed. Then you've got up to 4 months for the filing of the Rule 35 motion. Then you got the time for the judge to decide it. And then the time on appeal, which, even had we not pulled this case from oral argument in February, still would have been a significant period of time in between sentencing and when the case was decided on appeal. So, I mean, what do you base your statement on that in the great majority of cases, it's not going to be an issue?
Well, I base my statement on the fact that my understanding is that although we do C1C pleas in some misdemeanor cases, Mr. Healy is correct about that more often and more typically they're done in homicide and more serious cases in which both parties have an interest in reaching a defined sentence. I would also just point to the fact that the federal rules mirrored DC's current rules from roughly 1974 to 1987. And yet there's only one federal court of appeals case that addressed this issue. That there are many state rules that mirror the current DC rules. And yet, as Judge McLeese noted, there's a relative paucity of state court cases in this area, which I think is emblematic of the fact that this is not an issue that occurs with any frequency. This is the first time that this court is addressing this tension in the many decades that Rule 11 C1C pleas have been available and Rule 35 has existed in its current form. And so it just seems like a case in which it's unlike the other cases in which this court has exercised its discretion to address otherwise moot cases where the capable of repetition yet evading review standard is only met as to the first prong. Because in those cases, the court has talked about how it talks an issue that will consistently and recurringly evade review. That's in Ray Barlow, 634A second, 1248, or has talked about it involved overarching issues important to the resolution of an entire class of future cases. That's in Ray Johnson. It just seems that this issue is not arising with the same frequency and regularity as the cases in which this court has exercised its discretion, and thus the government thinks under this court's own standard, it should dismiss it as moot.
Mr. Lorenz, if we were to decide this issue on the merits and adopt a test like similar or perhaps one of the more restrictive versions that some of the other state courts have adopted of the similar test, would that have a significant impact on, from the government's perspective in some of these 11 C1C pleas? And would that be problematic to the administration of justice from the government's perspective?
I think it's hard to predict, but I think that any level of uncertainty into C1C pleas and the defendant's ability to come in immediately after that plea and obtain a lower sentence would make the government more reluctant to enter those pleas, or more reluctant to give the defendant the same benefits as part of the C1C plea as it does under the current standard, where the government has been proceeding under the assumption that these pleas are binding.
Can I ask you how binding you think they are? So do you think that, leave aside whatever additional terms might be in a plea agreement, but just by operation of the fact that something is an 11C1C plea, do you think that such a plea is impervious to a later 23-110 motion? So a defendant comes in and says, I pled guilty to 11C1C and I agreed to this disposition of the case and this sentence, but now I've got a claim that I can present under Rule 23.1 under DC Code 23.110, and I want that judgment to be changed. I want some convictions to be overturned. My sentence needs to be reduced. Is that foreclosed by an 11C1C plea?
No, Your Honor, it's not. Nor is compassionate release under the newly enacted statute foreclosed.
So we're in a world where it's not absolute certainty. It's certainty subject to other possible forms of relief. And I've asked you about one, but I have a whole list, so you can. I took the easiest one first. But how about? I assume you also think it's barring again a special agreement in the plea agreement. Is it impervious to a direct appeal?
Well, not barring an agreement in the plea agreement, but the government standard.
And how about a motion to withdraw a guilty plea post sentence under Rule 11?
I don't know the answer to that. I suspect those are possible in any case, although it's an incredibly restrictive standard for when the defendant can obtain that relief. But we're not talking here about other forms of relief.
I think we are conceptually, I guess. And so let me just ask you one more before we move off. How about a motion to correct an illegal sentence under Rule 35A? So again, imagine that there's a bunch of charges pending, and there's an 11C1C plea where all the charges are going to be dismissed except one, and people agree to a 7-year sentence, and then a couple of years later, the defendant realizes, wait, the single count of conviction carries a maximum sentence of 5 years. This can't be right. I want under Rule 35B that sentence corrected. Is that precluded by the fact that it was an 11C1C plea?
Again, I don't know. I suspect the answer is no, because
I'm puzzled conceptually then, because I thought your theory was, Rule 11C1C creates, it says the trial judge is bound, and that binding effect is not limited to the date of sentencing, and it persists thereafter. And it forecloses otherwise available relief under Rule 35B, because otherwise the finality that Rule 11C1C is intended to protect will be undermined in a way that is unacceptable. And if there are all these other remedies, some of which are statutory in character, but others of which are rule-driven in character, they're recognized, it's Rule 11 and Rule 35A. If they're all available, notwithstanding the language in C1C that you rely on, then I'm not quite sure conceptually why you carve out Rule 35B as categorically unavailable.
I think you carve out Rule 35B because it implicates the same decision that the judge just made at sentencing, that the parties agreed to. Well,
why doesn't 35A do the same thing? The parties agreed to this sentence, and now a defendant comes in under Rule 35A and says, I don't like that sentence. That sentence has a problem.
I'm sorry to interrupt, Your Honor. It's not that the defendant doesn't like the sentence. It's that the sentence is illegal. And it's not clear to me that the parties can agree to have the court impose what would otherwise be illegal to the court. But Rule 35B operates differently.
Well, no, but you could have the view, which I think is part of one of your strands of thinking, that even if some of these remedies might be available, what's unfair is to allow a defendant to keep the benefit of the plea agreement and then better it through these post-sentencing remedies. And so you could have the view that either under 23-110 or through direct appeal or through plea withdrawal doesn't work this way, but 35A, defendant can't just come in the hypothetical I gave and said, the government dismissed a bunch of charges and we all agreed I'd get a 7-year sentence on the one count. But that one count can only maxes out at 5, so I want you to reduce it to 5. One of your strands of thinking would be, well, that's not fair. Even if the defendant is right that there's a problem, you got to go back and let everybody. You can't let the defendant take advantage of that problem, no matter how fundamental. You got to pull the whole plea agreement apart because the defendant is sort of keeping half of a contract and trying to eliminate a piece of it. But you don't think that's true in the 35A setting?
Well, I think that's why that's the hardest one of those examples, Your Honor, because where the defendant moves to withdraw his plea, he's undoing the whole bargain. Where the defendant is filing a 23-110, he's presumably undoing the whole bargain and saying that he entered this plea due to ineffective assistance of counsel.
Well, no, actually, I don't think that's true. At least some like a 23-110 motion might be rooted in ineffectiveness relating to the plea itself, and then you would be trying to unravel the whole plea. But a defendant might well, his 23-110 argument might be, well, this, one of the, I pled guilty under 11C1C to 2 counts of conviction. One of them is unconstitutional, I now learn. And so I want it set aside under 23-110. That doesn't try to unravel the whole agreement. It says, I like most of the agreement, but you got to get rid of one of the counts of conviction. So it varies a lot depending on the nature of the 23-110 claim.
But as I understand what Your Honor just posited there, the defendant is still sentenced to the same amount, which is what the government is focused on in the 11C1C context.
Well, actually, I don't think that's, I guess I would say first, my hypothetical didn't entail that. If there were separate and consecutive sentences, eliminating one of the counts of conviction could affect the term of incarceration. I also think 11C1C is not only about how many months, but also about which convictions are going to be entered. That's an aspect, it talks about the disposition will be part of the judgment. And that includes I don't think the trial court could say, okay, everybody's agreed that the defendant is going to plead guilty to 2 counts and the overall sentence will be 7 years. And I accept that plea. And then at sentencing say, well, I'm actually going to set aside I'm only going to impose judgment on one of the counts for 7 years. That's part of the 11C1C plea is the adjudications of guilt people agree on as well, I think. Do you disagree?
No, that's true, Your Honor. But I think that it's not only the certainty of the sentence, it is the language of 11C1C, which is that it binds the court. And the Semler strain of cases and PDS's argument assumes that what that means is that the court is bound only at sentencing and not thereafter. And the government, when it enters a C1C plea, understands that there are levels of uncertainty posed by these possible post-trial motions, but that doesn't answer the question of what does it mean for the court to be bound by the plea agreement. And the government and the defendant are bound not just at sentencing, but thereafter. So we think the most sensible understanding of the Rule 11C1C's plain language is that the court is not just bound at sentencing, but is bound thereafter and thus precluded.
So, Leonard, let me ask you another question that kind of goes to the conceptual nature of all this. Let's assume that there's a C1C plea to an agreed upon sentence. And the defendant later cooperates with the government. And then both sides come back to the court and seek a reduction in sentence under Rule 35B. Now, obviously, if the court grants that request, the sense of unfairness to the government is absent from this hypothetical because the government is joining the request. But if we're talking about a trial judge's authority, I don't think that problem disappears. So how does the government, how do you suggest that we analyze that question? And I will tell you, I've had cases like that where someone has been sentenced under Rule 11C1C to a lengthy term of incarceration and then has come back on a joint motion for reduction on the ground of cooperation. The government obviously doesn't argue in that case that the court lacks authority.
Your Honor, I didn't know that was even possible. Typically, the sentencing for cooperating defendants occurs after the cooperation. There is a relatively short time limit to Rule 35B motions, 120 days, which would seem to also limit that problem. But as I understand it, the binds the court language in Rule 11C1C prohibits the court from granting relief. Now, as you said, if the government—
Can I ask you a question just to press you on that interpretation? You say that you would argue that the binding the court language in 11C1C goes beyond just the point of sentencing, but what would you say to the fact that you alluded to earlier that we did not amend Rule 35 in post 1987 language similar to the way the federal rule did. Therefore, it is a little more broad and gives more discretion to the trial court, which might seem to cut against your suggested interpretation that the language of the binding language in Rule 11C1C should be interpreted to go beyond the point of sentencing to the post-sentencing area.
I think that's where the history of the rules is particularly instructive. Rule 35, when it was enacted in essentially its present form in the 40s, there was no possibility of plea agreements at all under Rule 11. The plea agreement procedure, Rule 11, postdated the enactment of Rule 35 by several decades. And then it wasn't until 1999 that Rule 11 enacted binds the court language. And so we think that given that Rule 11 is a more recently enacted statute, that it's specific.
Yeah, but Mr. Laniers, that ignores the fact that after the federal courts significantly modified Rule 35B, the DC courts rejected that modification. So that came more recent in time than the Rule 11 enactment.
I'm not sure that's right, Your Honor. The courts didn't change Rule 35 because much of the federal changes to Rule 35 were part of the Sentencing Reform Act that simply didn't occur in DC. There were no binding mandatory sentencing guidelines that required courts to sentence a defendant within a certain range. And so all of this was part and parcel of a change in federal law that had no equivalent in DC.
Couldn't the DC courts have amended Rule 35B to say that only the government can seek a reduction in sentence based on substantial cooperation, which is essentially what the federal rule says now? Of course we could have done that, and we did.
It's true that Rule 35 hasn't been changed in any substantial form since, it was created in the 40s, but Rule 11 has been, and it has been most recently changed to make clear that C1C agreements bind the court. And so I think if the court is looking to plain language, which appears to be the primary basis for the public defender service argument, that the better view is that a court is bound not just at sentencing, but thereafter.
Can you explain? I mean, you acknowledged with respect to a bunch of other forms of relief, statutory or rule-based in character, Rule 11 C1C does not bind the tribal court, but you think with respect to Rule 35B it does. So I think that must mean you think that Rule 11 C1C binds the court post-sentencing for certain kinds of relief, but not others. And if you're going to explain like what the definition or the rule is about what kinds of relief are foreclosed by Rule 11 C1C post-sentencing relief and what kinds aren't, how would you articulate what the definition of the line?
I'm not sure I can draw a line that clearly delineates in every possible circumstance. I think, for example, when one looks at the DC Compassionate Release Act, it says notwithstanding any other provision of law. So that is a clear textual indication that courts may grant compassionate release, notwithstanding Rule 11 binding the court.
Okay, how about if we do it this way? Leave aside a global rule, which I guess I agree would be a significant task. But if you're going to explain why Rule 35A motions are not foreclosed by the somewhat binding nature of an 11C1C plea, but Rule 35B motions are foreclosed, you would say that is because ... The reason for that distinction, which you're saying exists, is because of what feature of each of the two kinds of relief?
So if I might be careful here, Your Honor, I said I wasn't sure if Rule 35A relief is barred, but I think it's probably not. So I don't want that to be a concession by the government for a problem that we haven't discussed and I haven't thought about. And so I think it's probably available sitting here today, but I don't want that to be a concession binding the government going forward. If I were to draw that line,
right.
if I were to draw that line, I think it's based on the fact that the government can't agree to bind the court to something that is illegal. And the court has, Rule 35A relief is available for an illegal sentence. And so that seems like a sort of clear legal rule that we can't make the court do something that it has no authority to begin with. That would distinguish Rule 35A relief from Rule 35B relief.
I have
Can I ask
another
a
question.
No, go ahead.
Okay, I have a question that just goes to the question of the court's authority, the trial court's authority. Suppose that the plea agreement is under Rule 11C1C is not to a specific sentence, but to a range. And suppose that the sentence imposed at sentencing is set somewhere above the bottom of that range. So let's say it's a 6 to 8 year sentence and a 6 to 8 year range, and the sentence is set at 7 years. Can that defendant file a motion, a Rule 35 motion for reduction of sentence, asking for a reduction down to 6 years? And does the judge have authority to grant that?
Yes, the defendant can file that motion and the judge has the authority to grant that. We think the Indiana court's opinion in Panaral makes sense in that regard. The range is what binds the, under the plain language of C1C, the recommended sentence or recommended sentencing range is what binds the court when it accepts the agreement. And so the court remains bound by that range. That doesn't preclude it from granting relief from 7 to 6 years in Your Honor's hypothetical, but it would preclude the court from granting relief below 6 years. And we think that's consistent with the plain language of Rule 11 and with the policy implications underlying the rules, which is the government agrees to a range, is seeking the certainty of that range, but it has no further interest once the court imposes 7 years in that 7 year sentence versus the 6 year sentence. The government.
Can I ask you about policy reasons? Because one of the points you make in support of your position is finality in 11C1C pleas is very important. And a doctrine that permits a defendant to go in and seek 35B relief, even under extraordinary circumstances, it damages that finality interest unacceptably. And your opponents respond in part. If the United States is concerned about finality and guilty pleas, it has a way of protecting that interest, if not perfectly, pretty close to perfectly, practically speaking, which is it can actually get specific waivers in plea agreements of particular kinds of relief. And that's routinely done for various forms of relief. And so why couldn't the United States' finality interest be largely, if not perfectly, protected by the United States putting in guilty pleas, trying to negotiate with them, with defendants who are willing to accept that, an agreement not to seek Rule 35B relief? I know that's not perfect because in theory, a judge who just accepted an 11C1C plea could, notwithstanding such an agreement, if there's a judicial authority to do this, could then turn around later and sua sponte grant 35B relief. But I think you'd be hard pressed to say that's a deep threat to the finality, practically speaking, to the finality of plea agreements. So what's wrong with the line of thinking that you have the ability yourself, independently of how we rule in this case, to largely protect the interests that you seem most concerned about?
So the fact that the court can do it sua sponte is one response to that, which is even if defendants don't move, the court retains the authority. I think that the other answer is that the ways the rules are structured Rule 35 does not seem to be meant to be a bargaining chip in the sentencing process that government needs to or supposed to address in C1C. Regardless, there are other interests that Rule 35 promotes that are not harmed by a C1C plea being binding on the court even sentencing. For example, the plea for leniency, the defendant has seemingly foregone that ability to beg leniency from the court were it to sentencing by agreeing to a binding sentence or a binding sentencing range. If I might also just address the proper test, I agree that there is a difference in the state court test. Similar, and some of the state courts have described the 35B test as to when the information must arise. And if this court were to not find this case moot and were to address the merits and to reject the government's reading, we would, of course, encourage the court to adopt the test adopted by the Tennessee court and others that have required not just that the information be newly presented to the court, but also that the information that arose post-sentencing. And we think that follows from the structure of the rules, which is that the court has the ability in a C1C plea at sentencing to reject the plea agreement. And so the defendant, if he believes that the sentence at the time of sentencing, when the court accepts the plea agreement and imposes sentencing on the same day, should have the incentive and the duty under the rules to bring any information to the court's attention then in his possession that can to make the agreement unfair or unjust. And thus that if the court reject the government's plain language argument and opt a rule based on the structure, sensible rules are not just that the information be newly presented to the court, but also that it be information that is
I'm sorry, Mr. Lorenz, could you repeat the last part of what you said? Your audio connection was a little difficult to hear.
I'm sorry, Your Honor. The Stemler court adopted a rule, and PDS has proposed a rule that the information merely be newly presented to the court, meaning that the information could have been created and known to the defendant prior to sentencing, but only be brought to the court's attention for the first time after sentencing, and that would be sufficient to support the 35B motion.
Mm-hmm.
The government believes that if the court rejects its argument, that the most sensible way to read Rule 35B in tandem with Rule 11 is to adopt a more restrictive standard like that adopted by the Tennessee court.
Is that Patterson, State v. Patterson?
Yes, Your Honor, which is that the information is not just newly presented to the court, but it's actually not known to the defendant or doesn't arise until post-sentencing. And we think that follows from the fact that the court has the ability under Rule 11C1C to protect the parties back.
Mr. Letters, I know we're over time, but I did want to get back to one. When drawing distinctions between the kinds of relief you think are available post-sentencing, notwithstanding 11C1C's language, and those that are, you said something which was the parties can't agree to something that is illegal. And I'm just wondering how that fits with the language in the plea agreement in this particular case. I don't know if you have that at hand, but one of the things that agreement says is that the defendant was going to waive challenges, including that the statute to which the defendant is pleading guilty is unconstitutional and that the conduct at issue didn't fall within the statute. So is it your position that those provisions in the plea agreement are not valid and not binding because they would be agreeing to something that would be contrary to law? You know, the defendant is guilty of an offense when actually the defendant isn't, because the Constitution says the defendant isn't, or because the conduct that was the predicate for the conviction doesn't meet the statute? Or do you think, in fact, that the parties can agree that the defendant will be bound by a plea, even if there is an argument later the defendant would like to make, then a court might accept that the plea had these kinds of fundamental illegalities in it?
I think that language is binding and appropriate language. I think the latter.
And do you think the parties, so do you think if it had said here, apropos of the hypothetical I was asking you, if it said also, if it specifically said, will the defendant waives any challenge that the sentence imposed is greater than is available under the applicable offense of conviction, you think that would be a valid and binding part of a plea agreement?
Yes, Your Honor, but there the defendant's waiver of his rights are knowing and intelligent, which seems to be and explicit, which seems to be a different scenario than where the parties apparently, in Your Honor's hypothetical, unknowingly and inadvertently agree to an illegal sentence.
Understood, but I guess, it sounds as though the parties can enter an agreement if it's knowing enough that will result in a binding plea agreement that would be contrary to law if the parties could step back from what they waived and raise various arguments. Is that fair?
If it's knowing, yes, because the defendant can waive any sorts of rights he might have, but has to do so knowingly and intelligently.
All right, thank you. Mr. Healy, we had indicated if you wanted a minute or two for rebuttal, we would allow that time.
Thank you, Your Honor. Very briefly, I have 3 points I'd like to make. You've asked whether the amici or amicus and the government are aligned in their agreement on mootness. My view is this: PDS institutional interests are not aligned with the class of people who have short sentences. By statute, PDS does not take misdemeanor cases. So there's very few short sentences or misdemeanor cases where this issue is likely to arise. Additionally, PDS tends not to take smaller felonies, the CF2 cases or the more less egregious CF3 cases. And these are the cases where this is going to arise. So the institutional view of, or the PDS's institutional interests are just simply not aligned with the class of people where this is going to arise. Secondly, the question of whether a defendant could file a CR motion has come up. That statute is specifically limited to felony cases and does not include people who are incarcerated for misdemeanors. So that is not an avenue for, again, someone who is serving a short sentence. And finally, I just would like to remind the court in the discussion of if you do find this case is not moot and go to craft a rule, I didn't ask for Mr. McBride's sentence to be reduced. I only asked for him to be sentenced to home confinement with electronic monitoring so he could pay for his own medical care, because BOP wasn't able to actually fulfill the obligation it had to him to provide the adequate medical care so he could rehabilitate his body. And I think that's an important distinction, just a fact of what was going on in the past. Thank you.
Mr. Healy, is that even something that's available under District of Columbia law? I mean, I know in federal court, people can get sent home on some kind of home confinement or compassionate release or temporary compassionate release, but I've never heard of that in being available in superior court. So I understood your motion as being one that must have been for a reduction of sentence.
Well, if I asked for something which was impossible, then that's my mistake. It's my understanding that it would be possible for that to happen. But if alternatively, Judge Salerno could have taken the same view as you, sir, and sua sponte decided to resentence him to, let's say, for example, a long split sentence, placing him at home for his rehabilitation while he's on a significant period of probation. And I guess I would also point out, as to the Chief's question about how this affects that supervised release, were the court to have sua sponte sentenced him to a long split, the supervised release period could have been suspended pending the conclusion of his probationary period. Thank you.
All right, thank you, Mr. Healy. Mr. Maneri, did you wish to have a minute or two for rebuttal as well?
Just very briefly, Your Honor, in response to the exchange between Judge McLeese and the government about how far the principle of finality can really take a C1C agreement, I do think it's important to point out the Supreme Court's decision in Freeman versus United States, where an analogous question came up as to whether 18 USC 3582C, which provides for modification of a sentence based on a later reduced sentencing guidelines, whether that could happen for a C1C agreement. And the Supreme Court dealt with a lot of these issues of finality there, and the government raised the same issues of C1C agreement, the importance of finality should supersede any other consideration, and the Supreme Court rejected that argument. And so I think in addition to the line drawing issues that the government and Judge McLeese were talking about, this court can look to Freeman for the point that, finality is important, but it's not the end all be all concern. And so that would be the only point that I would add. Thank you, Your Honors.
All right, thank you. I'd like to thank all parties for your briefs and arguments today. I'd like to thank the Public Defender Service for your amicus brief and for participating in the argument today. At this point, I think our courtroom clerk will adjourn the court for us.
This court is now adjourned.
Thank you, and you can feel free to exit our virtual courtroom. Thanks very much.